The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, the first case we're going to hear is United States versus Engin or NG. I'm not quite sure how to pronounce the name. You guys will clarify that. Ms. Trodden, we'll hear from you first.
Thank you, Your Honor. I'm Erin Trodden on behalf of Wilson Tita. Good morning, and may it please the court.
And you know, if you just speak up a little bit, that'll help.
Thank you, Your Honor. I'll do my best.
As if we're across the room, we are.
So as a matter of housekeeping, I will be addressing some of the sentencing and sufficiency issues common to all three defendants, Mr. Tita, Mr. Ng, and Mr. Fongu. My colleague, Mr. Wagner, will be addressing the issues related to the jury instructions, and my colleague, Mr. Isley, will be addressing the issues related to the exclusion of the defendant's expert. As to the other issues, because this case involves so many issues and we have such a limited time with you, we'd like to stand on the briefing. At the risk of beginning at the end, I'd like to start with Roger's Singletary error, just briefly, because I think that's the most straightforward issue we have here. In this case, the district court included in the written judgment two conditions that it did not pronounce orally at sentencing. It required in the written judgment that the defendants report to the probation officer when they lose their jobs or if they lose their jobs, and permit probation to remove any items that are prohibited by the conditions of supervision. This is Roger's Singletary error. These were conditions that were not pronounced at sentencing. They are additional substantive requirements on the defendants that are not clarifying conditions. And the district court did not incorporate by reference the standing order of the District of Maryland. Although the courts can do that, it must be done explicitly, and it was not done.
But the court did refer to the standard conditions, and we do have cases saying that's sufficient to incorporate. I mean, I think your problem is, not your problem, what's slightly different about this case is that after mentioning the standard conditions, the court went on to, as he said, kind of summarize them.
Exactly, Your Honor. So I think this case really is more like Bullis, where the court said standard conditions, but then went on to pronounce a number of conditions that really are at odds with the standard conditions.
But they're not at odds, right? I will tell you, my concern is we have a decision from last year, United States versus Turner, that was kind of similar. And we said we really don't want to fault the district court for, after incorporating, kind of going further and offering the extra protection of at least outlining the conditions for the defendant in court. And then if you give a little more detail in the written judgment, you're just sort of clarifying the summary you provided in court.
So two things, Your Honor. I think one, under the court's jurisprudence, this is not more detailed. These are not clarifying conditions. They're not fairly implied from the statements that the court made in court. Saying maintain employment does not give defendants fair notice that they have to notify probation 10 days in advance of changing jobs, or at the minimum 72 hours afterward. Defendants can be violated.
Yeah, no question. I mean, the court said at one of the sentencings, I'm going to summarize. And what the defendant got in open court was only a summary. There was additional detail that was added substantively in the written judgment. I agree with you on that.
And I think in both Mr. Fongu's and Mr. Ng's sentencing, the district court went on to say, in terms of standard conditions, and then went on to pronounce these other conditions that didn't incorporate this requirement. And Mr. Tita's—
I gather your position would be then, if the court had shut up after just adopting the standard conditions, it would have been better than the court having explained a few.
That is actually consistent with the court's statements,
I
because
know,
in
but
that.
I don't quite understand the logic of that.
I
In
think-
other words, the standard conditions are adopted, the defendant and the counsel have those available, they were in the pre-sentence report, and the court explains them, and not inconsistently, it doesn't try to change them, it explains them, at least I didn't see any inconsistency. You're saying that explaining some to the defendant somehow overrides the adoption of the standard conditions?
In United States versus Bullis, what this court said was where the district court says something that might be termed incorporating the standard conditions. Now, in Bullis, I think it's clearer. In this case, it simply said in terms of the standard conditions and then went on. But there's a conflict where the district court then pronounces conditions that are different from those standard conditions, which is what the district court did here.
I think
That
for
confusion.
for better or worse, we've gotten ourselves into a position where this is like a pretty fact-intensive inquiry, and you have to really look at the transcript and see if it is clear what's going on. And I just thought in looking at these transcripts, this struck me as different from Bullis. It seemed pretty clear that the district court was incorporating the standard conditions and then running through them more briefly than one would if you were reading them verbatim, but that's the point of first incorporating. You know where to look for the details, and now I'm just going to give you kind of a rough sense of what the conditions are in case there's any objection.
I understand the court's point. I would just say that incorporation of standard conditions is required by this court's precedent to be explicit. Where the court just mentions standard conditions and then goes on to say standard conditions, any reasonable hearer would assume that the standard conditions that the court is saying are the standard conditions. The standard conditions for the District of Maryland are not actually required to be included in every case, and so that's another way in which this case is actually.
But, okay.
Our position is, if you look at the transcript, you will see that they were not explicitly incorporated by reference. I want to touch on sufficiency because our time is so limited here. And I'd like to focus on sufficiency with respect to the mens rea aspect of count 4, which is really the linchpin of the defendant's argument. Obviously, while this court has
Which
to.
one was count 4?
Count 4 is the obliteration of serial
Obliteration,
number
okay,
count.
right, I understand.
So the defendants lacked the knowledge, the government hasn't shown that the defendants knew that the serial numbers were obliterated. And here I think really the question for the court is, what are the reasonable inferences that the court has to take in the government's favor? Because under the standard, the court gives the government the benefit of reasonable inferences. What the government, I think, is asking for here are more speculative leaps than reasonable inferences. The government leans heavily on the proximity of the defendants to Mr. Muma, who was the gentleman in the basement who was grinding off the serial numbers. But the evidence that was actually submitted does not support the weight that the government places on it. Mr. Muma, first of all, the basement's not 3 meters square, and the court should look at Exhibit 22, which is the video of the basement. It makes it plain not only the basement is a good deal bigger than 3 meters square, but that in addition, there's a wall between where Mr. Muma was working and where Mr. Ng and Mr. Fongu were working refurbishing ammunition, such that when Mr. Muma is working.
I understand all of that, and that sort of myopically focuses on a particular action being taken during, I think they said it takes 5 minutes to do one. But the bigger picture is almost is completely hard to overcome. These defendants met multiple times every single week over a long period of time, carrying on a function of trying to get weapons to Cameroon in a concealed fashion. They have bylaws, everything's confidential. They understand that the guns can be traced back and that caused problems, and they had to obliterate the serial numbers. And the serial number obliterations are big, coarse obliterations. I mean, you see the pictures, and it's 3 or 4 inches long. You can't miss it when you look at the firearm. And these people were packaging the firearm, concealing the firearms, handling them, renovating bullets. I mean, this was going on for months. It's a common effort in a closed place and just a few people. It's just hard to fathom that somebody didn't know what was going on, or I don't know if you're arguing that Pinkerton was foreseeable to as part of the conspiracy, but it seems to me the jury could apply normal common sense and inferences from all of that to say everybody there knew what was going on. I think it's an uphill battle when the jury is making that finding. You don't agree, but I'm giving you my reaction to it.
I understand, Your Honor. So you've said a lot, and I'd like to try and
Sure.
unpack some of that if I can. First of all, you talked about how the defendants were meeting and they were working collaboratively, and there is a lot of evidence about this group. And to be clear, there's no dispute that the defendants knew they were sending, or they were part of this group that was sending firearms to Cameroon. The issue is, did they know that those firearms had obliterated serial numbers? Now, in all of the evidence
Well,
and
except
all...
did they know what the nature of the whole operation was? The whole operation was high confidentiality. They had bylaws they actually passed. They controlled who came in and who knew about things. They knew they couldn't have the guns retraced back. That was actually explained. They prepared these guns daily. This wasn't one incident of missing a 5-minute grinding. This is a routine thing done for all the guns. And how many times it happened? 35 times at least, maybe many more. We don't know how many guns have been shipped in prior times. And these guys are there, 3 times a week, 4 times a week in that small basement? I saw the video, and I think it's a hard case to make. I think the jury saying, you're sitting in a room and you're all coloring, and one guy's looking at the wall and coloring a picture, and the question is, did you know anybody else in the room was coloring? He said, no, I was looking at my own picture, even though there were other children behind him coloring. I mean, it's, what are they doing? And the markings, this is not a small thing. You don't have to just hear the grinding, you can see the gun. I mean, the marking is big, and it's ugly. It defaces the firearm. And I saw the pictures and thought, how could anybody miss that the serial numbers were not ground off?
I see my time is up.
Yeah,
May I respond?
Yes, respond to that, sure.
With respect to your comment about or your question about the markings, first of all, on the guns, I think the government relies on this, but when you look at what the government found when they raided the basement, none of the guns that were in the basement there's no evidence that the serial numbers on those guns lying around were obliterated. So I don't think that we know that, and the government hasn't offered any evidence, that the guns that were in the basement that the defendants might have seen had obliterated serial numbers. We don't know where in the process that happened. The government has access to the universe of information about the conversations between these gentlemen. They have all of the communications, all of the group messages, and they have, as cooperators, the 2 people who are most involved in the obliteration of serial numbers, Mr. Muma, who did it, and Mr. St. Michael, who was the gun guy for the group. They could have offered testimony about any of these things, about any communications, about any of this, but if you'll notice, there is no testimony, 1, that they directly discussed this, 2, that the group discussed as a general matter the need to obliterate serial numbers or the need to be cautious about serial numbers in Cameroon. When you look at the interests in concealment that the defendants had, they're really interested in 2 things. They're concealing their activities in the basement and what they're doing in the US, and they're concealing the shipment. But there's no interest in concealment in the group at large.
But there is a manufacturing process that has been repeated and repeated and repeated, and the evidence allows the inference that all of them knew what was going on in that basement on a regular basis. And all the firearms that were recovered had obliterated serial numbers. And it seems to me as part of the process of their whole function of supporting the Anglophone side in the Cameroon dispute. But anyway, I hear what you're saying, and what we have to worry about is, did the jury have enough to make that decision?
And if I might just make two more points, Your Honor, in response to your comment. First of all, it wasn't all of the firearms. There were a few firearms that did not have obliterated serial numbers. But I think more broadly, your concern about they must have all known because they were in the basement doesn't hold up when you realize that something like 0.2% of the time that Mr. Muma spent in the basement was time spent grinding off the serial numbers, taking all of the possible
But it was
inferences.
repeated for every gun, and it was a loud grinding noise. And this is an operation. How many steps in preparing these guns was there a loud grinding noise, except with respect to the? I mean, they weren't sawing off the tips of the shotguns with saws. There's a lot of common sense. I mean, I know you would like to focus on a 5-minute effort and say that 5 minutes is a small percentage of the whole time they were there, but I'm not sure that's the way we look at things when we experience them.
Well, I think
But I think your time is up, and we'll take it up. I guess you have some rebuttal on that.
Thank you, Your Honor.
Mr. Wagner?
Good morning, and may it please the court. I'm Rob Wagner. I represent Mr. Najee in this case, and I'll be addressing the jury instructions, the instructions that were read to the jury at the conclusion of the evidence in this case. And it's important to reflect, Your Honors, on the nature of this conspiracy and the nature of what these folks were doing. They were documenting just about everything, and they were communicating on a regular basis about everything that was going on. And if you look through all of the emails, all of the texts, all the social media, voicemails, letters, writings, if you look at the co-conspirators and their statements about what was going on here, the discussions that they were having, there is no specific reference to serial numbers. Now,
There's no specific reference. They're using code. They're acting in confidence. They have words that substitute for other words, but they didn't describe the process, how they did ammunition and so forth. This is a detail in the manufacturing process. But regardless, what is your objection? I mean, both of the instructions were accurately described the law, right?
no question, Judge.
Okay, so your objection is that they gave a Pinkerton,
Yes, sir.
a Pinkerton instruction because cutting codes, grinding off codes was not a foreseeable function of the conspiracy.
That and several other things. It wasn't just the serial numbers charged that the jury was provided under Pinkerton. It was counts 2 and 3 as well, the export counts as well. This was a complex
I mean,
case, Judge.
you're suggesting that there was no evidence that these people knew that this stuff was going to Cameroon?
Oh, no, not at all. The jury found them not guilty of those 2 counts, Judge. No.
Well, I understand.
What I'm suggesting is there was insufficient evidence that they were aware of the grinding of serial numbers. And I know you've hit on that, but more importantly, Judge, this was a toxic combination of instructions. You've got Pinkerton, which allows for vicarious liability of underlings of the principals in this case. And that's unusual. And then you've got the willful blindness instruction on top of that. And you've got a conspiracy instruction that allows inferences in the case, inferences that can be drawn. And then you've got an aiding and abetting instruction on top of that. These defendants had no actual engagement, actual participation in the serial numbers, in the obliteration of the serial numbers, yet they're being held vicariously liable through the Pinkerton instruction, through the willful blindness instruction. And I think we need to look at this case and these defendants in that proper context. Now, the case law that I cited in my briefs discusses Pinkerton and discusses that, generally speaking, in a Pinkerton case, you've got a principal who's being held liable for the conduct of the underlings. Here, we're reversing that. Here, the government and the district court has instructed the jury to find vicarious liability, Pinkerton vicarious liability, for the agents from what the principals knew. And not only do you have the reasonable foreseeability standard for Pinkerton, but you've got a standard that allows for, Judge Harris?
Oh, I'm sorry, how do we know who are the agents and who are the, I'm sorry, I can't.
Well,
I thought part of the case that was made to the jury was that this is like a very non-hierarchical kind of a conspiracy. It was these 10 guys, they were social friends, had all sorts of ties to each other, and they kind of were all in it together.
Well, I think it's clear that St. Michael, the man who owned that house and who controlled the operation, he was overseeing everything. He gave Muma, Mr. Muma was perhaps the principal witness for the government, not perhaps, he was the principal witness for the government about the obliteration of serial numbers. And so you've got St. Michael giving instructions to Muma, and then you've got these guys who weren't even involved in the obliteration of serial numbers. And I would suggest that they didn't specifically know of the obliteration of serial numbers, nor even that it was reasonably foreseeable, because there was no discussion of that. And it was in a separate space from where they were working, and the timing of when they were there wasn't clear. But you also...
Wasn't there even evidence from Muma that he was instructed to grind off the serial numbers in the earshot of the other twos, that they would have heard the instruction?
Yeah, but he said that they
Wasn't that
weren't...
evidence in the record?
Oh, no, that is in the record, Judge, that they were perhaps there, but that
And if they hear the instruction to Muma to go off and grind the instructions, don't they assume that he then went and ground off the serial numbers?
But Muma specifically said that he couldn't testify. He couldn't present evidence to the jury that they heard what Muma instructed.
No, he said it was in earshot. They could have heard it. They were right.
Could have heard it,
Yeah,
right,
sure.
right. And I don't think we should be resting...
This is not a large group of people there at the same time.
No, that's
A few
clear.
people.
But it was a finite number of guns that were involved.
Yeah,
And he
but-
said that at most he grinded, what, 10, less than 15, more than 10 firearms at between 3 and 4 minutes and 5 minutes for each of those
I'm sorry,
firearms
just
over
going
a
back
period
to
of months.
sort of the nature of the conspiracy. I mean, it does seem as though nobody was making any effort to keep the grinding part from the other members. I feel that, given the government's case at trial, why is it unreasonable for a jury to infer that because the instructions about obliteration were given in front of other members of the conspiracy and the grinding was done in front of other members of the conspiracy, why isn't it a reasonable inference that all of the members of the conspiracy knew what was going on? There was no effort to sort of hive this off.
I understand your point, Judge, but if you look at the exhibits in the case, and if you look at where the toilet was, where the grinding tool was, and they talked about a tire next to the toilet, and on that tire, that's where the grinding was. You can't see that tire. You can't see that
Well,
toilet
I know, but if it's
in
a
any of the
secret
pictures.
from the other members of the conspiracy, like from what I could tell from the video, there's not even a door. Like, no one is making any effort to keep this quiet.
But there are a lot of other things going on. It's not just the grind. There's the packaging of the ammunition. They're actually supplying legitimate humanitarian aid to their countrymen back in Cameroon. They're providing diapers. They're providing formula. They're providing vehicles and blankets and clothing.
In the basement?
I'm sorry?
In the basement there?
Well, that was being
lab?
packaged. No, the basement
We're
was...
talking about what's going on in the lab.
But we're talking about packaging generally as well, and what was going into the storage container that was being sent to
Well, that's-
Nigeria.
Sure, that's like saying what they had for lunch upstairs, but, I mean, we have this fairly small confined room, very congested, a few people in it, and they're doing various functions together to get these firearms prepared and packaged and concealed, heavily concealed and packaged. I think they, down there, didn't they actually put it inside some kind of a tank?
A container, yes.
And welded it closed? I mean,
That's
with foam?
true.
I mean, and isn't everybody know what's going on? I mean, it's
I see my time is up, Judge, if I may
okay.
respond to your question. You know, yes, in terms of packaging firearms, in terms of packaging ammunition, in terms of sending these materials overseas to the continent of Africa, yes, everyone knew. But you can't extend that to knowledge of the obliteration of serial numbers.
Okay.
Thank you.
All right. I guess Mr. Isley will have you.
Good morning, Your Honor. May it please the court. My name is Justin Isley. I'm from the Sadiq Law Firm, and we're here on behalf of Mr. Fongu. We're here to argue the point about the complete exclusion of defense expert Effie Timbon. Our clients were clear in their reason for presenting this expert: to educate the jury in the ongoing conflict that involved violence against certain citizens of Cameroon by their government, and to explain why people may
What is the relevance? In other words, your expert was going to suggest, at least the court was worried about it, that supporting one side of a conflict in Cameroon was a justification, something that would legitimize the conduct. And the court thought that was going to cause confusion. The court let the information in through other witnesses, but the court excluded the expert, which would highlight and focus on the dispute in Cameroon as opposed to these criminal violations of the American Criminal Code.
Your Honor,
it's a
this
discretionary decision, and the court's making this assessment, and you got that evidence in through other witnesses.
Your Honor, it is an abuse of discretion standard. However, the law has to be followed. The expert testimony was not in violation.
What law was violated?
Your Honor, the expert witness would have provided
No, what law was violated?
the rules of evidence were not followed by the trial court. Our expert, despite having a point of view, was appropriate expert evidence, and it was necessary because our client's defense needed this. The government was arguing that our client's concealment of actions in this entire case as a proxy for the proof of their mens rea for a guilty mind. And our clients have a right not just to make them do it through their own testimony, but to have expert testimony that can, if the jury believed, could lend them to believe that our client's point of view on their mental state, the reason for concealing was not to hide against the United States. And government experts do it all the time.
The mental state is knowingly, but there's no, I don't believe, maybe you can point it out, but I don't think there's any justification defense because you're supporting a legitimate revolutionary movement.
Your Honor, our expert meets the criteria for expert witnesses under the rules of evidence. And the recent case in Diaz shows that our experts were well within the protocols. When a government expert, this case, as Your Honors know, came out while this was on appeal, a government expert was able to testify that most people in a group, that included the defendant in that case, share the mental state, and that this did not violate Rule 704, because 704 only allows for the defendant's mental state to be excluded. Our expert was not going to testify about what our client's mental state was. It was just going to lend evidence and credibility to their point of view.
Is there any dispute that you guys had these bylaws, that you had the overall effort to support the revolutionary, the Anglophones? It seems to me that the jury knew exactly what they were doing, but there was no suggestion that that justified. Now, clearly that's why they were doing it, but at the same time they were doing it knowingly, and the knowingly aspect violates American law.
To the extent the court excluded this expert under 403, when there is probative value to the evidence, this court has said, and other courts have said several times, that you lean to introduction of the evidence. That's because we have, and I quote, vigorous cross-examination,
What is it going to prove?
presentation of
You said
contrary
it's-
evidence, and
sir-
careful instructions on the law.
What is it? You said it's probative evidence. What was
It's
it gonna
probative
prove?
evidence. The government is saying that all the actions that our clients were saying is as a
No, I'm
proxy for their
asking
mental
you,
state.
what is the expert going to prove?
What is the effort is going to provide relevant evidence about the ongoing conflict that shows that people would suffer retribution from actions from the government if they were found out. And our clients testified, Your Honor just said previously, that this already came in through our clients. They said that they were worried about the criminal.
But I don't understand why the expert was needed to put that in. I don't understand how that relates to an element of the offense.
It's the guilty state of mind. It's the mens rea that, as just
What is the mens rea?
the guilty. They have to prove that our client's intent was to conceal these things from the U.S. government. And
No, they didn't. They had to be knowingly conceal, deliberately conceal.
when government experts testify,
Not conceal, it's basically
Your Honor,
to
when government-
obliterate, knowingly obliterate the arms, knowingly export the arms, possess the arms. I mean,
Your Honor, when government experts testify, and I would like to finish up with this. When government experts testify, it's not because it's necessary. It's not because the evidence isn't already in. And I'll give two quick examples. We see this in drug cases. Government experts of this type, non-scientific ones, are allowed liberally. We have them, as in the Diaz case, or drug experts. Almost in all cases in those times, you will have the elements proven through cooperating witnesses and other testimony. So they don't need the gang experts say, this is what the code is, this is what that is. Your Honor, in the same context would say, well, that should be cumulative.
Okay.
You also have sexual abuse cases where the victim testifies. Maybe they have some inconsistency in their statement or their delayed reporting, but they've laid the elements of the offense. But you still allow government experts to come in and testify about maybe why the mental state of that victim, delayed reporting, or other things.
okay, I think your time's up, and you can cover the rest on rebuttal. Ms. Munoz?
May it please the court, MJ Kirsch-Munoz for the United States. The defendants take aim at pretty much every...
Keep your voice up.
The defendants take aim at pretty much every aspect of the pretrial, trial, and sentencing proceedings below. But this scattershot approach cannot disguise, much less overcome, the correctness of the district court's rulings and the integrity of the jury's guilty verdicts. You know, guilty verdicts that, like any jury verdict, demands deference under the Rule 29 standard, which sets up an enormously high burden for the defendants here. And because we believe that the defendants come nowhere close to carrying this burden, we respectfully ask the court to affirm. And unless your honors have a preference otherwise, I think I'd like to start with where your honors left off on the issue of excluding Mr. Tembon's testimony. And I think there's really no question that the exclusion of Mr. Tembon's testimony was at least within the discretion of the district court here, if not entirely the correct call. And there are 2 points I want to emphasize on this topic. The first is that despite what defendants now argue, they gave the court almost no sense, no real proffer about what Mr. Tembon was going to say. In fact, the court really only had 2 sources that abstractly described what Mr. Tembon's testimony was going to be. That would be a single sentence in defendant's 4-page notice, which is at page 134 of the appendix, and Mr. Tembon's congressional testimony that was attached to the notice. And both of those sources, if one were to read them, I think entirely confirm the district court's judgment to exclude this testimony. And so I just want to make that point totally clear, that although defendants now say, oh, Mr. Tembon wouldn't have testified like he did in his extremely partisan congressional testimony, oh, and Mr. Tembon would not have invited the jury explicitly or implicitly to pick his side in the Cameroonian conflict, that was by no means apparent to the court as it was ruling on defendant's notice. And so I think the court's concerns about confusing the jury with some sort of sideshow about who is right and who is wrong in this conflict were very real. And those concerns alone justify the court's decision to exclude Mr. Tembon's testimony. But my second point is that on top of this tendency to confuse the jury about, what was really at stake in this case, Mr. Tembon's testimony really had very little probative value. The government is not disagreeing that it was in some abstract way relevant. The district court also agreed that it was relevant, and that's what the 403 standard actually sets out. If there's relevant evidence, should it still be excluded when balancing the probative value over the tendency to confuse the jury, mislead, prejudice, et cetera?
And how would it have confused the jury?
So, Your Honor, the district court found that the testimony that would most likely include a lot of description of the violence in this Cameroonian civil war would create a little bit of a sideshow, a mini trial about the different sides in that conflict, who was right, who was wrong. And I think the court was also extremely concerned that by allowing the jury to identify with one side in the conflict, they would be.
But wasn't it the government's theory about the Pinkerton and all those things that everything that was done must have been a natural consequence of a foreseeable act, like the grinding, because they wanted to hide from prosecution in terms of they knew this was against federal law? Wasn't that your theory? That's why everything that was done in the room, well, you must have known that because you want to grind the guns down because you wanted to conceal the crime. Wasn't that your theory to the jury?
The defendant's theory was that
No,
they
not
wanted
the defendant. Tell me the
sorry.
government.
Yes,
Wasn't that your theory?
the government's theory was
And
that
you
they-
wanted to paint a picture that these people are in this room, they would do whatever is necessary to conceal everything. That's why they must have known that they were grinding these serial numbers. They were doing all these things for that purpose, right? A nefarious purpose of, just hiding themselves because they didn't want to be prosecuted or be caught and violating the federal law, correct?
Yes.
Wasn't that your theory?
That is the government's theory, yes.
Well, then, why would it not be appropriate to say no? Then if you open that door, to say, wait a minute, no. Even though it's not a legal defense in a sense, perhaps, maybe not, but no, there's a conflict going on and there's dangers related to that aspect of it and not wanting to be, right? To be caught by, to be brutalized by the other side in that war. Why wouldn't that give another context to it? So in other words, the government can put all these things on that are negative and give that idea, but they can't put on a different perspective of it. Why not?
Well, Your Honor, I think I have 2 points there.
Yes, please.
The first is that the defense did, in fact, put on plenty of evidence, plenty of testimony from certainly the 2 defendants who did testify
But
as
they
well.
wanted an expert. Everybody knows that an expert does better, right? Because, right, a lot of people say, well, a layperson could have talked about this, but yeah, but an expert, they get the jurors' attention, right? Because they're the only ones that are allowed in a court to give an opinion. Everyone else is a fact witness. They can give opinions. That's what makes them different in terms of, I know you're a good trial lawyer, you know that. Experts, that makes the difference because jurors, they know them. If you do a good job as a litigator, they sit up and say an expert because they're qualified by the court to give an opinion. Why should they be bereft of that? And you can paint this picture, these people are just concealing everything because they're criminals, just like anybody like that. You treat them like, well, these are like drug cases, they're always trying to get rid of this stuff, what they're cutting it with, what they do, who they're supplying, who the connect is. No, what he was saying that there's something that's beyond that. It's the whole thing to motivate in terms of what's going on, the atrocities or whatever that they're dealing with and where they are. Why would that be confusing and why would that not be? I don't understand that.
So I think the district court's ruling, aside from the tendency to confuse the jury, was just that there was really no need for an expert to establish the kind of facts that that the 4-page notice of expert testimony said Mr. Tembon would do. That notice said, and I quote, "The testimony will explain to the jury that the Cameroonian government has been involved in an armed conflict with Anglophone Cameroonians since at least 2016. And that's it, and that's all it said. And I think the district court was well within its discretion to say, okay, the fact that there's a civil war in Cameroon is relevant. The fact that the Cameroonian government retaliates against people is certainly relevant, but defendants don't need an expert to establish these facts. A jury is perfectly capable of understanding on its own the concept of retaliation, the concept of why someone who is arming, a foreign militia, insurgents against the government, wouldn't want the foreign government to know that they were doing that. And so I do think that is, that's certainly a ruling within the district court's discretion. And I think that's another reason why perhaps, the government's expert witnesses in gang cases are a little bit different. I think gang experts typically opine on things that are clearly not within the reach of the average juror. We're talking about
You think
jargon,
the average American
symbols.
knows about what's going on in African conflicts?
Sorry, I missed
You
that.
think the average American knows what's going on in African countries and conflicts? Do you think that?
No, I don't think that, Your
Well,
Honor,
that's
but
what you used as the reason why we need an expert for the government about drugs, didn't it? I'm just trying to follow your logic.
so again, like the fact that a civil war is ongoing in Cameroon, there was plenty of evidence in that by the defendants.
By whom?
By defendants, witnesses, like Mr. St. Michael, as well as the government's witnesses, Mr. Acom, Mr. Muma.
But not an expert, though. They wouldn't allow an expert.
That's correct, Your Honor, and.
So why would that be confusing to have an expert?
Well, I think the judge was concerned, as I said, that this would sort of devolve into a mini trial about, the purity of the defendant's motives and sending it to the, quote, right side of this Cameroonian conflict. And I think that a jury, or rather an expert wasn't needed to establish the pure fact, as again the notice said the testimony would, the pure fact that there is a civil war in Cameroon. I mean, that was undisputed, and the district court allowed plenty of room for testimony on that point to come in. And so I do think that's, as I mentioned before, maybe one reason why gang expert testimony is a little different. The handshakes its members use, the jargon, symbols, tattoos, like those things aren't within the reach of the average juror. I think most people, on the other hand, are fully capable of understanding that a government in the middle of a civil war wouldn't treat kindly people who arm the side against which the government is fighting. I think I will also, given that I've already spent 10 minutes on this topic, I would like to address the sufficiency of the evidence on count 4, which is the obliterated firearms count. And I think Judge Niemeyer has it right. The evidence was more than sufficient for a juror to reasonably infer that defendants had actual knowledge of the obliteration of the firearms, or at least that they deliberately avoided knowledge of it. I would, of course, rest, or maybe not rest, rather, but just repeat the framing here, which is the Rule 29 standard. Every presumption in favor of the jury must be indulged. All inferences from the evidence must be construed in the government's favor. And after all that, after all the presumptions have been applied and all of the inferences have been drawn, the jury verdict must be upheld unless no rational trier of fact, not a single one, could have found guilt on all the essential elements beyond a reasonable doubt. And so, the government's position is that there was plenty of evidence here from which to infer knowledge. And we can start.
And the knowledge is that they were in the room when obliteration occurred?
That's certainly one category of evidence that the government, has. Mr. Muma, which I believe the jury credited, said that he went with Mr. NG and Mr. Fongu 8 out of 10 times that they went to the lab. The three of them were together. Mr. Tita was also there often, according to Mr. Muma. And, he also testified as to the distinctive loud noise that the grinder made. And he said it would take up to 5 minutes to grind each of the identifying marks off of each of the firearms. And this was a very attention-grabbing act. Mr. Muma, aside from the noise that the grinder made, Mr. Muma was in special goggles, he was in special gloves. He did testify that he could see the people in the other part of the basement when he was back in the room grinding, which of course permits a reasonable inference that other people could see him, and that's on page 936 and 937 of the appendix.
Is it in testimony that he discussed the grinding process with them at all? Any evidence for that?
No, Your Honor, there's no direct evidence here, but you know, that's of course not required. A jury is permitted to.
I thought he was given an instruction to carry on the grinding in the presence of the others.
Yes, in the presence, he and Mr. St. Michael had a conversation in the presence of two of the defendants about the obliteration. And of course, that is yet another piece of evidence from
The
which.
evidence is, what was the conversation?
The evidence is that Mr. St. Michael assigned Mr. Muma the task of obliterating the firearms in the presence of the defendants. And, you know,
And how far away were they, do you know? What was the evidence?
we don't have exact.
It's not in the record, is it?
No, but of course, we know the size of the.
We know how, through the evidence?
Yes, yes, Your Honor, the jury had the video of the evidence, or I'm sorry, of the lab. Agent Matney took the video and introduced it, and you know, she walks down the stairs and goes through the lab, and the
There's
jury.
no question they were in the lab. The question I'm talking about the connection with the grinding.
So, I mean, the grinding took place in the lab.
So
And
therefore, their presence was enough? Is that it must be their presence in the lab is enough, right?
I think it's sufficient for a reasonable juror to infer that they knew what was going on, that they knew that Mr. Muma was obliterating serial numbers off of firearms. But, Your Honor, that's not, you know, all the evidence that the government has. You know, it of course behooves defendants to, you know, take each piece of evidence piecemeal or each category of evidence piecemeal. But, you know, the question is, what does the complete picture represent? And
Well, the
here,
complete pictures, they were putting all kinds of things in the storage thing, right? Supplies, medical things, things that sustain people. So if you talk about the whole thing, if anybody's narrowing it down, it's the government.
well,
right?
I think those sort of humanitarian aims took place outside of the basement, and the testimony is undisputed on that point. Inside the basement is where all of the concealment happened. And, you know, I would just point again to the depth of all of the defendants' involvement in this long-running, close-knit conspiracy, in which concealment was the name of the game. We, of course, have the bylaws drafted by Mr. Tita that talk about concealment being the, you know, the priority of the group, and what's the word he used? Our most secret prized possession. Prized possession is concealment. And of course, those same bylaws also distinguish between council members and non-council members. All the defendants in this case were council members. They were no mere stooges of the conspiracy. They all had leadership-like roles. You know, Mr. NG was taking minutes, Mr. Tita was meeting with investors. You know, the defendants were deeply involved in this conspiracy, and that's another piece of evidence that could be sufficient on its own, but certainly in tandem with the defendant's presence in the basement, from which a reasonable juror can infer that the degree of their involvement in the conspiracy means that they knew or must have known or deliberately avoided knowledge of the obliterated firearms. I also want to point out that Mr. Vangu and Mr. NG testified, and I think some of their testimony was really quite incredible. They blanketly disavowed knowledge of many things, of, you know, what the paperwork would have said, what, you know, the licensure procedure was, and I think the jury was entitled to view some of their particular testimonies as, again, you know, another way to infer that, you know, they're not telling the whole truth. They knew what was going on. And, you know, on that point, I will quote Mr. Muma as saying, "All of us knew," this is a direct quote from 937, "all of us knew what was being done in the basement," is what he said.
What about the enhancement for the
Yes.
28 weapons or more, more than 25?
Yes, more than 25. And, you know, I think the application of that guideline is really quite straightforward. It asks whether the offense involved more than a certain number of firearms. And
But you
so,
have to use the offense of conviction, don't you? And what they were convicted of is just said one or more.
well, so the offense, yes, means offensive conviction or relevant conduct, and we don't need to leave.
Aren't you required to it's the offense of conviction here, right?
Yes, that is the government's position. We don't need to look at relevant conduct.
Yeah, but was convicted of just one or more. Isn't it? What's evidence allowed that the amount that he was charged to get to the level of sentencing? Isn't that a problem here in this case?
Your Honor, I don't think that's a problem here. I would say that the determination that the jury was required to make is a different determination than sentencing accountability under this particular guideline, which again only asks whether the offense involved. And I would note also that the offense of conviction is defined in the guidelines as the offense, and I quote, the offense conduct charged in the count of the indictment or information of which the defendant was convicted. And so I think there was more than enough here based on, of course, what was charged, the offense conduct charged.
What was he convicted of that would give you 28 weapons were involved?
So, we don't know what if the jury made any particular finding as to number of
Exactly. That's the problem. It's
Yes, but, again, what the jury was
like quantity of
asked to...
drugs. You have to find some quantities that justifies that conviction. Here, what he was convicted of is one or more. How do you get to that level where they went to by that conviction?
Well, again, I think the factual finding that the jury was required to make is a different determination than the one the court was required to make. It only needed to ask and find whether more than 25 firearms were involved.
Maybe the jury found there was one. That's all they had to do, one.
Right, and the district court was entitled to find that there was more involved. It didn't have to rely on the jury.
Wait a minute, based on the conviction?
Based on the trial evidence.
It's the conviction, isn't it?
I'm sorry, I didn't.
It's the conviction that we're looking at. How do you determine that quantity of drugs based on what he was convicted of?
Well, again, whether an offense involved is a certain number of firearms is a different question than whether, the defendant's...
Then you're saying you can stray in terms of what's involved. So even if you're convicted of an offense that's 3 grams of cocaine, you could say, when I sentence you, this involved 3 keys somewhere out here. How do you stretch that beyond what was convicted? It was a jury trial. There was conviction. You put it before them. And now you're saying you can sentence it and enhance it. Isn't that a problem?
Well, I do think that there are determinations that a district court makes at sentencing that are different and distinct from the conviction. I think there are a number of enhancements that have to be based on...
What you're trying to say, I think, and not saying it too clearly, is that the enhancement is a finding that has to be made by the court based on what the court heard and saw.
That's
and
correct.
Not on the jury was not asked to find a number. The jury just find whether firearms were the serial numbers were obliterated.
Right.
And so the court determines as a matter of sentencing whether the amount involved in that conviction, a number of arms exceeded 25. And the court found that it did.
Yes.
And implied the enhancement.
Does it have to be proven? It has to be proven, doesn't it?
By a preponderance standard, yes.
By preponderance?
For a sentencing enhancement, yes, Your Honor.
Well, but you have to go by what's convicted of. I mean, isn't that it almost got an apprentice problem there in the sense that changes, because if it was one, that wouldn't qualify, right, for the level that he enhanced, right?
I think theoretically, if the jury convicted only of one firearm, which of course we don't know, that doesn't preclude the district court from later making a sentencing determination that, more than just one firearm was involved in the offense. And I apologize if I'm being...
This wasn't a departure.
No, it was an enhancement.
It was an enhancement based on, and the jury at least would have to show that in terms of what was he convicted of. In terms of that, you could just go ahead and, so what you're saying, basically the judge could say, well, I'm going to sentence him based on 1,000 weapons.
Well, of course, the judge would have to make a finding that 1,000 weapons were involved in the offense. And the district court here said, the trial evidence showed that more than 25 firearms were involved in this offense. And of course, that's not just because the offense conduct charged included, a list of 28 firearms on count 4 and 39 firearms on count 5, but the trial evidence proved that up. In fact, defendants did not dispute that the number of firearms that were recovered from the shipping container, nor did they dispute the number of firearms that had obliterated serial numbers. And so, you know, I do think that the application of this guideline is really relatively straightforward. Does the offense conduct as charged and as proven at trial involve more than 25 firearms? And the same is true, you know, lest I move on without addressing, the same is true for the second enhancement. We have just been talking about 2K21B1C, and there was a second enhancement under subsection B5 if the defendant engaged in the trafficking of firearms, increased by 4 levels. And I think here defendants don't even dispute that they transported firearms. What they really dispute is that whether they knew if the firearms that they transported had serial numbers that were obliterated. And so I think the second enhancement here was appropriate as well. Let's see. I honestly, if the court has no further questions, you know,
Okay.
I am just over 5 minutes, but I am happy to stand on the briefs and to cede the rest of my time unless the court has any other questions.
Thank you. All right, I think we now go to Ms. Trodden, right?
Thank you, Your Honor.
Can I just jump in and ask you a question about the enhancements, the sentencing enhancements? Was it the defendant's position that, is it the defendant's position that it's an Apprendi violation to apply enhancements on a preponderance standard based on relevant conduct found by the judge, the district court? I'm just confused as to what the argument is as to the enhancements now. I didn't understand the defendants to be making that argument.
No, we're not making that
Okay.
argument. It's not about Apprendi. It's really about 2 things. One is the mismatch that Judge Gregory captured between the offense of conviction, where the jury only had to find at least 1 firearm, and the enhancements, which required specific numbers.
But why is that a problem if the district court can find that this offense involved the right number of firearms as relevant conduct?
The district court can find that, but that's not actually what the district court found here. When you look at the transcripts, and the cites are in the briefing, what the district court relied on was the simple fact of the convictions in this case. And so they didn't actually make the specific findings needed given this disputed issue and given the government's burden to prove that this actually amounted to relevant conduct as to each of the
Okay,
defendants.
so that's not an Evans argument.
It is an Evans argument, yes.
It
So
is.
that's the second argument.
Evans wasn't about, okay.
That's the second argument. So that in addition to this mismatch.
Okay, so there's 2 different arguments.
Yes.
Okay.
There's
that's
a
what
there's
I
a
was missing. I
mismatch.
thought we just had an Evans argument.
And then there's also the Evans argument with respect to the fact that Pinkerton liability, which was a basis for the conviction, is broader than guidelines liability. And in addition, I would point out that subsection B5, relevant conduct, specifically narrows the relevant conduct that the court can consider to not include jointly undertaken criminal activity. And the district court didn't wrestle with that at all.
But on the Evans argument, I mean, I think I've heard several times already today. Look, everybody admits that the defendants knew about the guns. What they didn't know is that they were obliterated. This just doesn't seem like an Evans case to me, where the defendant's argument was, you know, this is a spoken hub conspiracy. It would be as if one of your clients said, look, my only interaction with this conspiracy is I sold them 1 gun.
Mm-hmm.
The full extent of my involvement in this conspiracy had to do with 1 gun sale. So you can't charge me with knowing about the other 28. But no one is saying that here. Everyone is saying, yeah, I knew about the guns, plural. I just didn't know they didn't have a serial number. So I guess I'm not seeing how this is an Evans problem.
I think it's an Evans problem because of the nature of the guideline, which is looking at not the guns in toto, but the guns with obliterated serial
No, it's
numbers.
not.
No, it says the
That's
guns
not the
involved.
guideline.
It
When
just
you-
says firearms involved. In other words, it's a factual finding that if there's more than 25 firearms involved in the offense, then you enhance.
But the offense was obliterated firearms.
Exactly,
Yeah,
Your
that's
Honor.
the difference. This is not just generally firearms. That was specific.
What's the language of the enhancement?
I don't have it in front of me, Your Honor.
I understand.
Okay, thank you. Mr. Wagner?
May it please the court. I'd like to point to the Ravenel case. 2023 case from this court gave this quote: "Instructing the jury clearly regarding the law to be applied to the case is a prerequisite of fulfilling the Sixth Amendment's promise of trial by an impartial jury. Without proper instructions as to the law, the jury becomes mired in a factual morass, unable to draw the appropriate legal conclusions based on the facts." This jury was instructed under Pinkerton that if the defendant could have reasonably foreseen that the substantive crime might have been committed, then the jury must find the defendants guilty. Under willful blindness, the jury was instructed that there needed to be evidence that the defendants deliberately ignored clear indications of wrongdoing. There was no such evidence. The jury was also instructed as to inferences that could be drawn under the conspiracy count to find that it was a knowing engagement in the conspiracy. And then there was the aiding and abetting instruction on top of that. You put those all together, and the standard to which the government was held was below that of a reasonable doubt. And we would ask that you reverse this case and remand to the district court due to the improper jury instructions.
Thank you.
Thank you.
Mr. Heisley?
One minute for rebuttal. We'll see. Your Honors, thank you for hearing us today. Again, I go back to the joint appendix where the trial court, and I quote, stated that the expert can't come in and offer testimony that is essentially supposed to prove the defendant's state of mind. That is complete contradiction to the holding in Diaz versus United States. The government was allowed to introduce this exact type of evidence.
I thought your argument was the objection to your expert being excluded. Did you object to the government's expert? Is that on appeal?
No, Your Honor, we're arguing that our expert was excluded for
I
saying.
know, but that doesn't, we shouldn't have to now go into whether the government's expert was properly admitted or not, because that wasn't preserved and is not argued, and we haven't looked at the circumstances. But the question is whether the court properly excluded your expert.
Of course, Your Honor.
With respect to the statement proffered.
Of course, Your Honor. And what I'm saying, Your Honor, is for the exact reason that our expert was excluded is the reason that the government's expert in Diaz was allowed. We made no objections to the government's expert below in that regard that we're raising here. But what we're saying is the equal standard should apply to both the defense and the prosecution. And that's exactly what Justice Jackson said in her concurring in Diaz, that this type of analysis under 704B can benefit defense attorneys and their use of experts as well. So we're asking that the rules apply equally to both government experts and defense experts, and so that our clients can have a fair trial. Thank you.
All right, thank you. We have several appointments of people who are representing by appointment or by pro bono, various voluntary work supporting our system, and I really want to recognize that. It's so important. I'm proud of our American system where we bring defendants in and we give them the same level of defense that the government has, and you guys have done a nice job. We'll come down to Greek Council and proceed on to the next case. right, next case we'll hear this morning is United States versus Murray. And Mr. Walker, whenever you're ready, we'll hear from you.
Good morning, sir.
May it please the court. I'm Richard Walker. I am one of the Assistant Federal Public Defenders in the Northern District of West Virginia. I represent Richard Johnson. The court knows the issue in this case is sufficiency of the evidence as to count 6, which charges possession of 2 firearms in furtherance of a drug crime that was charged in count 2. Mr. Johnson was acquitted of count 2. He was convicted of conspiracy. He was acquitted of count 2. I think the heroin charge was dismissed. He pleaded guilty to count 7. But the focus is count 6. And our position, very simply, is that there was not sufficient evidence to support that conviction because Mr. Johnson was merely present. I mean, this is a case about two firearms that were, in my opinion, incorrectly attributed by the government to Mr. Johnson because he was in the home.
I'm sorry, I just want to make sure I understand.
Yes.
There wasn't sufficient evidence from which the jury could infer what exactly? That he knew about the guns?
That he
owned
had
the guns?
advanced knowledge of the presence of the firearms.
Okay, so it's about advanced
Under Rosemont.
knowledge. That's the only thing you're contesting?
Correct.
Okay.
This is just comes down to whether there's sufficient evidence of Mr. Johnson's knowledge. And in this case, like Blue,
And I'm sorry, what he has to know is
the guns are there. He has
Okay.
to know the guns are there.
Very
And I rely on Blue. And
Why don't we talk about the evidence?
I'm happy to. That's what I know best. I've been living with this case for a long time. Mr. Johnson was merely present. He was basically a squatter because the key facts are no witness saw Mr. Johnson with the firearms. He was not the owner of this residence. He was not on a lease for this residence.
You got a lot of evidence there, but face the hard evidence. Mr. Johnson was a supplier to Mr. Murray of drugs. He lived there for a month in that trailer with Mr. Murray, and the two worked together in the distribution of drug business.
But he didn't have dominion.
Just a minute,
Yes,
please.
sir.
And when the officers came in, all the drugs are being prepared on the table in the room to the right, which looks like the common room because it has a sofa and the television and other things. And there's a holster on the desk in plain view, and the guns are right there on the shelf in a bag.
Right.
And evidence was that when they came to knock, the sheriffs came to knock and they identified themselves. They waited for a minute, maybe more. I watched the tape. It seemed like a long time while there was some scampering. The guy answered the door, but then he didn't open the door for over a minute. And the guns ended up within arm's reach, right on the shelf above the drugs. So we have a drug conspiracy, pretty clear drug conspiracy lasting probably for quite a period of time. Mr. Johnson is probably the supplier. They're probably working together, and we have a gun holster lying on the table, and we have the guns in a bag right above the table on the shelf.
It's
and
so
you're
different.
saying he did not have knowledge of the presence of a gun there.
There was no evidence of it. It's so different than the last case. I listened to that case with great interest where, as you described, one theory is all these gentlemen are in a basement with a grinder and they're openly handling firearms and manipulating them. In this case, there's absolutely no evidence of that. Mr. Johnson was in the back of the residence. Mr. Murray was in the front of the residence. The front room, there's no it is a common area only because people called it a common area.
Well, you could look at the tape. I mean,
You can look
come in the front door, and right there to the right is this common room. The sofa, the only sofa in the unit is there.
Yeah.
The television, the only television is there.
Right.
They each have a computer.
There was
in the front
another
and the back.
television. There was
And
another
the drugs
television.
are up front on the table, all kinds of drugs paraphernalia.
There was another television in the
And
back.
they're in this together, and he's been there for a month.
That's not how it occurred. That's not what the evidence support. With all due respect, I understand that view of the case. It is not the complete view, and quite frankly, it is not the most accurate view. There was another TV in the back of the room, in the back of the building. There was a bed in the back of the building, and that was where Mr. Johnson's room was. Mr. Murray is over 7 foot. He laid on that couch. That was his room. This was not a typically domesticated home. It was dilapidated. There was no owner. There was no lease. It was a trap house. Let's call it what it was. But Mr. Murray lived in that front room. That's what you could fairly extrapolate from all of the evidence. That's where he was located. That's where his backpack was. That's where his sweatpants were. That's where all his gear was. All of his food was there. I mean, these were not close friends. They were not really even roommates. Let's assume Johnson's the supplier. All he does is go to Detroit, come back, drop off the drugs, gives it to Murray. Murray packages it up. He distributes it to all the people he knew, because Murray, he's not from West Virginia. He's from Philadelphia. He was our center on the basketball team. He knows everybody, and everybody knows him. So he's the one who takes care of the drugs, who packages the drugs, who distributes the drugs. And the guns were in that room. I don't think there's evidence that Murray knew the firearms were there. There were people in this residence coming and going. Neither of them seemed to have exclusive dominion and control of the residence, because neither was on a lease and neither was an owner. But Johnson especially, with all due respect to Mr. Murray, Johnson especially had no ties, significant ties to this building. So while there are competing views of the case.
Can I just stop
Yes.
you on the competing
Yes.
views? Because I feel like what you just made was a very persuasive argument to a jury, and I think a reasonable jury could have adopted it, but there is another way of looking at it, and I mean, you have to show that no reasonable jury could have
Right.
adopted one of these two competing views you're laying out.
Absolutely, and it's a deferential standard, and of course I acknowledge that today, and I acknowledge it in my brief. But as I say in the brief, and this is not language from the Fourth Circuit, but I think it's been cited by courts, by maybe Moy, there must be some action. Johnson made no action. There must be some word. Johnson made no statement. Or there must be some conduct. We can presume what his conduct was. I mean, the government has this idea, but it's really more of a dream or a theory, that he's there at the front table in the front room with Murray, organizing all
Let me
these.
ask you a hypothetical.
But may I just finish my response to that?
Let me just get my question here.
Absolutely, sir.
It's a hypothetical. If the guns are lying, those two guns were actually lying on the table, could we infer that Johnson, who supplied the drugs, would have brought them to Murray and would have seen the guns on the table?
You have to, because the case law indicates
No,
that
could you infer, you would agree that's a fair inference?
you'd have to determine, your case law, the precedent in this circuit would require this court to make a finding of sufficient evidence, because plain view cases are different, and that's what we see in the case law.
Now we have the circumstance where there is a delay at the door. Obviously, Murray is reacting to this announcement that the sheriffs are at the door.
Is that in the record?
Yes.
That he was obviously,
No.
Just a
no,
minute.
it's not.
Just a
He
minute.
could have also been asleep
Just a-
at 4 in the morning. He
No,
could have been
he
asleep.
answered the door. He came to the door,
He did.
answered, and then there was a noise. And the question is, there was a holster on the desk in plain view. So we have two guns that we don't know whether were on the table at that moment, but maybe common sense might suggest it to a jury. But we had a holster on the table, and you agreed that Johnson would have seen what was on that table on a regular basis, bringing drugs to Murray
No.
in that room.
I don't agree with that, because
How does he get
there
the
would-
drugs?
He could have. We don't know where those drugs were transferred. The drugs
So
don't.
they live together. They live together in a conspiracy.
Well,
for
they
a
really
month.
they really didn't live together. They were occupying this location.
Didn't they live in the same trailer?
Mr. Johnson was
Did
in.
they live in the
Mr.
same trailer? We'll take a yes or no.
No, Mr. Johnson was there. He didn't live there. It wasn't his home. He never used that address as his address. He's a nomadic, at best, in the light most favorable to the government. He's a nomadic drug dealer who had no ties to West
Evidence shows
Virginia.
that he had been living in that trailer for a month, in the back room.
I think he had been present there. Living there is probably not the term that I would
Living there means
use.
staying overnight, sleeping there.
He slept there.
I mean,
He slept there.
Your
But
brief calls him an unofficial subtenant. Like,
who calls him that?
Your brief.
I don't remember using that language.
I
I think.
guarantee you did.
Well,
'cause
I
wrote
think
it
he's
down.
the brief. Yes, he's essentially a squatter. He's a guest of someone who didn't have the authority to invite him, Mr. Murray, because Mr. Murray didn't have a lease. He was trying to get a lease. He was trying to establish a lease. I just disagree with the characterization. I don't think it's accurate to say that this was a home where they lived and they interacted. One man lived in the front. One man slept in the back. Murray was intending to establish this as a residence, and this is I think an important point as it relates to the holster. There's no evidence that Johnson saw the holster because there's no evidence that Johnson was ever in that front room, or there was no evidence that he would need to be in that front room. That was where Murray's stuff was. We know that because, again, if you look at the video, he was our center. When I mean our center, he played basketball for WVU. It's basically our college team, our pro team, all wrapped up in one. So he had WVU gear all throughout that front room. The methamphetamine was in, I think, a WVU backpack or in sweatpants that were WVU. So I think it was a backpack, a WVU backpack. That's where he kept all his gear. He struggled with a drug problem, and he set up in that front room. That's where all of his stuff was. So if anybody saw the holster, it would have been Mr. Murray. Now, another thing about the holster, if you look at the video and the pictures, the holster is small and black, the table is black. It's not so easy to see. So let's just assume, again, based on the hypothetical, that Mr. Johnson was in the front room at some point. There's no reason that he would have seen that holster. Again, very different than this case where all these gentlemen were from Cameroon, and there's a grinder, and it's loud, and there's a sort of open and notorious activity occurring that if anyone else in that basement would be there, they would hear someone grinding off something, a serial number, something very significant. There's no reason to believe that Mr. Johnson saw that holster. And the government's other argument dealing with what could be considered the difficult evidence is that Mr. Johnson was not in proximity to the firearms. Again, when the police arrived at the residence, Mr. Johnson was in the back of the residence. So there was proximity between the guns and the drugs. There was proximity between the holster and the drugs and the guns, but there was no proximity to Mr. Johnson. So again, because he wasn't an owner, because he wasn't on the lease, because he didn't have a key, because no one saw him with the firearms, because he was not very well established there, maybe a month, maybe not the whole time, because he wasn't very well established, and because he didn't exercise dominion and control over that residence, it's different than many cases that have been decided where there had been sufficient evidence, and I think it's a lot like Blue. So I'm out of time. Unless the court has another question, I'll
All right, thank you.
move on. Thank you.
Mr. Frame?
Good morning, Your Honors, and may it please the Court. I'm David Frame here on behalf of Eric Murray, and I would begin by saying I'm very grateful that you want to talk about the facts, because really that's really what matters. There's dozens of cases on this point, presumptions that mostly arise out of vehicular cases. A recent one is the Davis case. I don't remember if any of you were on the panel. It's a very obvious case. He's the sole occupant. He's the owner of the vehicle. The butt of the gun is sticking up between the seats, and the inference is pretty clear. But even in that case, the court went out of its way to point out there's no strict liability. These are presumptions, that essentially rebuttable presumptions. And so the first point of fact that I want to begin with is that Deputy Ward, who was the lead deputy in this investigation that morning, testified at trial that he could not rule out that those guns were placed there by someone else. Now, why is that? If you start...
Well, I guess I don't understand how that would be inconsistent in any way with both defendants knowing they were there. They could have been placed there by someone else. They could have been owned by someone else. But at least your colleague was telling me the only question in this case, it's not about who owned them. It's just about, did they know they were there?
Well, of course, but knowing they're there is just a presumption. No, there was no direct evidence. There was no, again, several cases in this circuit have quoted the Pardo Sixth Circuit case saying there has to be some word, there has to be some connection, something more than the presumption. Let me tell you what happened. In that room, the guns were found in a green bag, and Judge, forgive me, but I take issue with your comment, in arm's reach. Not in arm's reach. Like a lot of vehicular cases, they are literally, proximity means arm's reach. In this case, not in arm's reach, but in the same room, in a bag described as a cloth bag, I think maybe with a zipper enclosure, but described as being closed. The government did not preserve that bag and any evidence it might have about who it belonged to or who put those guns there. And again, the deputy admitted he could not rule out, because here's the other evidence you have to consider. You can't just allow an inference based on a presumption. The other evidence is that there were numerous people occupying or in and out of the trailer. There was not a stick of furniture in the entire trailer that belonged to Mr. Murray. All the appliances, there was a washer and a dryer, the television, all the chairs and tables. The only thing that was in that trailer that belonged to Mr. Murray actually was, probably the clothing that he had on and some other things scattered around. So that's a factor. The fact that the green bag.
Why is that a factor? He's a tenant. He rented it. He was trying to actually sign a lease. He was in the process of going through that situation. How long was he there? A couple of months?
I think the evidence was a month or more, and it wasn't
more than a month, because Johnson was there a month.
Okay, right, yeah, okay. But the point of the other furniture is that other people had access to it too. In fact, we're not just
I don't know
talking.
if they had access. They came there to, probably for deliveries.
There were personal letters. There was a four-wheeler parked outside that did not belong to either of these defendants, and there was lots of property all throughout
It was a trap house.
Well, it may have been a trap house, but it also was a place where people lived.
No, you're laughing, but you don't understand that. That's the whole point. It was a place where people trafficked all the time. And unfortunately, they stay there. They use there. Generally, the trap house, right? And therefore, it's not like, well, this is a place where only two people live there, whatever, we can presume everything. The people were coming and going, and that's why it was such a Spartan place, probably.
Well, I think that diminishes the inference. In one case, you have in this circuit the Black case, and I think you were on the panel, actually. It's an old case.
I wrote the opinion.
Yeah, it's an old case, but in that case...
It's not old, it's just, it's vintage.
It's vintage, right. But in that case, there were only two occupants in the apartment. There was a guy and a girl, and the gun was either his or hers, and she flipped. She testified at trial. No, I've never seen that gun, and it was in the drawer right beside where he always slept on that couch. In this case, you have multiple people, who have apparently been in and out, still have property there. In fact, the manager of the trailer park came and testified that someone named Lisa Johnson had originally leased it for her son, who just got out of prison. She didn't know where he was, though. He'd lived there for a while with his girlfriend, and then they were gone. So that diminishes the inference that because my client was an occupant of the building that he knew that the guns were there. Again, you have the green bag, which went missing. The gun was tested for fingerprints. Guess what? There was a fingerprint. Not Mr. Murray, though, and not Mr. Johnson. Did the police investigate further who that print belonged to? They didn't. They chose not to. No testing of DNA evidence. The bag is gone, so we can't tell if there's any information there that would suggest to you. So in other words, all the presumptions apply. I don't dispute that, but they're disputable. And when you take the totality, which again, this is why I'm glad you're doing a factual analysis, the totality, there are lots of things that diminish from that inference, and I don't think we quite get there. It's suspicious. It's evidence upon which the police certainly should say, hey, we better look into this further. But it's not enough, and that's basically our case, that if you go to, and again, the language of Pardo, if you don't mind me citing it, quoted in 2 different cases in our circuit, there must be some action, some word, some conduct that links the individual to the contraband, indicate he had some stake, a power over them. There must be something to prove the individual was not merely an incidental bystander.
Okay, thank you.
Thank you, Judge.
All right, Ms. Wesley.
Good morning. May it please the court, I'm Zelda Wesley. I'm here on behalf of the government today. Want to start talking about residency. It is clear, and the jurors made a reasonable inference that both these defendants resided in that residence. Interestingly, in the body camera with Johnson, at 7 minutes and 45 seconds in it, he acknowledges that he had been residing there in that trailer with Mr. Johnson, with Mr. Murray for about a month. Mr. Murray made the same admission in a different body camera, where he said he'd been living there for 1 to 2 months, and he actually referred to Mr. Johnson as his roommate. And that occurred in the transport video at 20 minutes and 20 seconds. So both these men are living together in this trailer. What's interesting is the common area, which is, when you look at the video, the only real livable space in this trailer. And what's real interesting about that is when you consider the evidence that was taken from the flip phone that belonged to Mr. Johnson's, which was the Alcatel flip phone, it makes it really clear, and the jurors can draw any reference, that Mr. Johnson was the source of supply and Mr. Murray was his runner. There are communications where there were like customer service complaints where people were contacting Mr. Johnson and saying, 7 foot, because that's what they called him, he's not meeting me, he was rude when he made the delivery, he tossed dope at me. They were complaining to Mr. Johnson about Mr. Murray's conduct. There were communications where Mr. Murray was saying to Mr. Johnson, I've got the bread and I'm going to bring it to you. So the flip phone of Mr. Johnson makes it really clear that these two had a drug relationship and that they were engaged in making distributions. And that is the reason why that drug packaging table in that common area is so important, because we know from the phone that they are packaging drugs, they're making distributions, and that common area is exactly where all of this stuff transpired. On that table, there was Narcan for overdoses, there were syringes, there were needles, there was baking soda, there was crack, there was residue, there was a drug ledger, and there was a notebook which detailed pricing for drugs based upon different quantities that would be sold, all with the holster. And what's interesting about the holster is Deputy Ward on his video, when he walks in, and before he does the walk around to see if there is a hostage situation, he says to the 2 officers, I want eyes on both of them because I see the holster on the table, which refutes any suggestion that that holster wasn't readily visible to anyone who walked in that room. That is immediately on the body camera video from Mr. Ward when he goes into the residence. And it's also important to note that when he's taking Mr. Murray away to the station, and he's having a conversation with him about the things that I think we're going to find in the house, he says, I'm pretty certain I'm going to find a gun in there. And that's based upon seeing that holster on that table in plain view. And that's a reasonable inference because a holster has one point. The only thing a holster can do is basically be used for a firearm. And it is reasonably for those jurors to conclude that the presence of that holster meant that there was a firearm in the residence. And that is the same packaging table where...
Tom, and are you separating this, as you recount the facts, the 2 different defendants? That applies to Mr. Johnson too, that he would know that?
It applies to Mr. Johnson as well.
Why?
Mr. Johnson is the source of supply, and that is the packaging table. Any juror can reasonably infer that both men, the one who's bringing the drugs down from Detroit and the 2 that are packaging these drugs and selling them, they're doing it at that table. Everything that was needed to cut those drugs, to package them, is right on that packaging table in that common area.
And what drugs were on the table?
Crack cocaine was on the table, Your Honor.
Crack cocaine.
Crack cocaine.
Anything else?
There was some residue, I think it was powder cocaine, is my recollection, that was on that table as well. And of course, it was wrapped up, the way that they packaged it, they wrapped it up in a notebook. There was residue in the notebook, also found on that table. Everything that was necessary to make that business run. There was even a list of what to do if someone has a drug overdose. All of that was contained on that packaging
So
table.
under your theory, I would suppose in terms of the logical extension of your argument is that if Johnson was not present at all when the police officer came in, and the room was just like you described it, if he walked up on the porch, he would be guilty of everything you found, even though he wasn't there at the time, just because he lives there, right?
No, because of his phone activity.
That's
We-
what I'm saying.
we-
I'm taking all of those facts. The only thing,
Okay.
the difference is that he's not there at all when you come, and later he comes, say 15 minutes later. He would be guilty of all of the things you said, the gun and everything.
So he's,
I mean, he could, right, that was inappropriate, because jury could take an inference, make the inference, right?
well, it's a totality question, Your Honor. Here's the other part. So we talked about the Alcatel flip phone. I want to now talk about the Motorola phone. There were two phones that were seized. Both phones belonged to Mr. Johnson. The Motorola phone, there were communications between Mr. Johnson and someone who had a 313 area code, which is Detroit, Michigan. And what he was trying to do was find someone to sit with him while he is making drug distributions. And he offered to pay $3,000 plus food and weed if a person would come down and sit with him for a week or two. The reason that that is important is that is the role that can be reasonably inferred from 7 Foot and Mr. Johnson, for two reasons. One, 7 Foot is a big presence, and when the search was executed, seized from Mr. Murray was approximately $6,500 in cash, and seized from Mr. Murray was approximately $2,700, and I may have flipped up the numbers, but there was about $9,000 total. But the point of it is that Mr. Murray had more money than Mr. Johnson.
On the table, there was money too, right?
There was money was in table, and the point of Mr. Johnson having less money than Mr. Murray, there's a inference that can be drawn that's because Mr. Murray ended up with the money for the protection or the money to, get my back. That's what he was trying to do. And Mr. Johnson is the source of supply, but the person who's the runner had more money than the source. And it would be easy for a jury to infer that he found the person who was going to watch his back and who was going to protect him while he was making his drug distributions, which would be the reason that the runner had more money than the source.
You told the jury this?
I'm sorry, what, sir?
That was told to the jury, what you just said?
I don't recall if I did or not, Your Honor.
Sound like you did. I mean, you know it pretty much line to line. I mean, it's like a novella. I mean, you basically weave this thing well. I mean, I guess jurors will, I guess, if that's the kind of evidence you put before them, in that sense but.
I'm sorry, I didn't mean to interrupt you.
No, go ahead.
No, he made it clear in the Motorola phone that he needed someone to protect him. And what the jurors also heard was from two witnesses that helped them understand how this drug enterprise worked. They heard from Mark Trump, who's a DEO task force officer, who explained to the jurors that firearms are important in drug distributions, and that Drug dealers are robbed not only by their customers, but they're also robbed by fellow drug dealers, which is the reason why firearms are important. And then they also heard from Deputy Ward on cross-examination that wasn't elicited from the government, but he was asked about the accessibility to firearms. And what Deputy Ward testified to was that firearms are useful in drug enterprises, and that the drug packing station was in close proximity to the guns, and that, and this is as much as a quote as I can recall, that if you were in that drug packaging area, you had ready access to the firearm because it was close to the drug station, and that came out on cross-examination by him.
Can I ask you just, sort of backing off the facts for a minute? I'm trying to figure out, I'm not sure I've seen a aiding and abetting charge on a 924C possession case before. So, I mean, I think what all the defendants are challenging is knowledge, but did you also have to prove that one or the other of these defendants actually owned, possessed the guns?
No, so what we had to prove is that the firearm was present and it had the ability to further the drug crime.
Yeah, but you didn't have to prove that one of them possessed it?
Constructive possession.
So, okay, so you had to prove, so one of them had to have like control and
Yes.
dominion over it, okay, but
The-
you didn't know which one? Is that why you charged it as aiding and abetting?
That is correct.
Okay.
And that they had to have the ability to exercise dominion and control.
Okay,
And one of the things that, one of the things that I think the jurors can infer is that based upon this location to the drug packaging station, that those firearms, loaded firearms, were equally available and accessible to both those defendants, based upon this close proximity to the packaging table and the fact
How
that,
far, there was some challenge, one counsel said that there was not close to the table. I thought it was.
it is, Your Honor. And so when you look at the body cam video, it makes it clear how small that room is and how close basically everything is in that room. But in addition to that, Your Honor, in the joint appendix, there are pictures that were taken, and pictures number 826, 827, 828, and 829 are various pictures within the room. And joint appendix picture 826 shows the shelf where the bag was, where the firearms were contained.
Was that a shelf on the same wall which the table was against?
Yes, Your Honor. And in picture 827, it actually shows the packaging table, and you can see in that picture the holster right above
Yeah, I've
the
seen
box
that.
of gloves
I've
in
seen
the
that.
picture.
I've also seen the tape,
Okay.
the video.
Yes, but when you look at that, you can tell that it's a small room and that everything is in close proximity. Deputy Ward testified that it was easily accessible because of its close proximity, the firearms to the drug packaging table. One of the things that I think that it was noteworthy is that when he suggests that, when Mr. Walker suggests that Mr. Johnson was in the back time at the entrance, it ignores the fact that the sole purpose really of this residence is for drug distributions. And the packaging of the drugs that were to be distributed, it appears from the video, and the jurors can infer, was exclusively in this drug packaging table, which was self-contained. Everything that was necessary to run their drug business was in that common room at that table. And for those reasons, Your Honor, we contend that there was sufficient evidence for the jurors to infer that both men had knowledge. The firearms were obviously needed not only to protect themselves, to protect their drug proceeds, and to protect their drugs. There was approximately $3,400 worth of meth that was still in the apartment that day. So in total sum, approximately $12,000 was in that residence. And so if the court has any additional inquiries, I realize I have 5 minutes left, but if there are no additional questions, I'll cede my time.
All right, thank you, Ms. Wesley. All right, we'll hear from Mr. Walker.
Thank you again. I want to make it very clear, we don't dispute any of the drug evidence. We didn't argue about that much at trial. Drug conspiracy, we admit that. Drugs in the residence, we admit all of that. The government has that, ample evidence to support all of those convictions. I just want to make the point that no matter the quantum of drug evidence, none of it will ever be a substitute for knowledge, for proof of knowledge of the presence of these firearms. And I think that the government has made a valiant effort to try to sort of conflate those concepts, especially by calling the so-called experts to talk about, well, you know, you just have to have guns if you're going to have drugs. You don't.
But isn't, that's one of, sorry, I have found this case just a little bit confusing because they did have to prove that not only that your clients knew about the guns, but that your clients knew they were there in furtherance of a drug conspiracy.
Right.
And the expert testimony, I thought, bore most directly on that.
I think the government intended to use that for two purposes. I think the government wanted to use that expert testimony to show that the firearms were in furtherance of a drug crime, which, by the way, my client was acquitted of the drug crime that it was allegedly in furtherance of, but also to...
But he was convicted on some drug
He was convicted of
offenses, right?
conspiracy, but only count 2, which is possession with
I know,
intent
it's the only one that
was
was cited,
was
yeah.
charged, was the predicate for the 924C charge. My client was acquitted of that charge. But the government, I think the government's intention and their argument in the brief is that, well, you know, you just have to sort of believe that people know that the guns are there because they're drug dealers. And that's an improper argument. There's a fine line between drawing an inference and speculating. And obviously our position in this case is that there is a lot of speculation, and that, quite frankly, the jury had to go beyond fair inference and enter the realm of speculation and supposition in order to make this finding as to Mr. Johnson. I think the district court, with all due respect, extrapolated beyond what is reasonable in order to find that Mr. Johnson had knowledge of the firearms. And I think you can see that, you know, because there's no direct evidence, and I think there's no fair circumstantial evidence, what the government is doing to do its job is sort of trying to identify little hotspots in the case, such as the drug packaging station. Again, we never agreed that it's a drug packaging, that table was a drug packaging station.
What was it?
It's a desk. It's a desk with Murray's junk on it, and a holster, and some coins, and some cash, and some other items. I mean, it's right there in the video. It is also not next to the guns. That's something that's very important. The desk was against a wall. The guns were on another shelf.
On the same wall,
No,
right?
no, sir. On another, I would like to respectfully correct that. The guns were on another shelf on another wall. It's a small room. I mean, I don't think that really makes...
Very small room, but...
It doesn't make a big difference, but this was not an area where everything was organized and set up and where it was clearly an area to package drugs. It could have just as easily been an area where someone used drugs at one point in time. It could have just as much been an area where Murray alone packaged drugs, or someone else.
I hear you, and I know you have to make these arguments, but when you make an argument like that, it almost sounds silly when you have a pad there with prices and instructions, and you have cutting agents, and you have syringes, and you have overdose items, and you have packaging, and you have thousands of dollars rolled up on the table, and a gun holster. I mean, what is this table? And you actually have drugs on the table. This is, to call it just a table, is very
it had
aggressive.
multiple. I think it had multiple uses, and I think Murray, regrettably, has a very serious drug problem. But Murray also lived in that front room, so it was his desk where he put his stuff. It was probably an area where he used drugs. It was probably an area where he used drugs with other people, and it was probably an area where he did package or hold some of the drugs that he would
There's
leave.
evidence of them actually distributing. There are complaints about his distribution
There's-
methods and failing
Murray.
to show up
Murray.
to Johnson about Murray. And
No, that phone, the jury never made a finding that the
they don't make
Motorola,
any findings. They just filed guilt or innocence.
they didn't have to find that it was
No, I'm
Johnson's.
suggesting to you that that table was for drug distribution.
In part.
As the officer told him right as he came in the front door.
In part,
That-
in part, but not necessarily Johnson. And that, the flip phone, again, looking for another
So
little,
what the gun's doing there?
that's the thing, there's no evidence of what the
I said,
guns,
what are the guns doing there?
there's no evidence of what the guns are doing there.
What's your speculation?
I'm not going to speculate because that's what the government's been doing for 4 years. The guns were there, we don't know who put them there.
We have said the presence of guns close to drugs
Right.
is, you can draw an inference.
You can draw an inference that they're used in furtherance of the drug crime. You can't draw an inference because they're present. The case law says that. Mere presence, mere proximity, knowledge, I mean, these things cannot be
It's a
presumed.
context. And if you conclude that that was a drug distribution table, they had customers, that they were in a conspiracy to distribute drugs, they had been living there for a month together doing that people came there to buy drugs, and then you have two guns there near the table, and a holster on the table.
And there's context in blue, and there's
question-
context in blue too, because he's there, and there's a kilo of cocaine there, and there's a gun there, and there's nobody else in the car. But there was never any action or word or conduct to suggest that Blue had knowledge of the firearm, and this court, in my opinion, rightly concluded that there was insufficient evidence. Thank you for considering my position.
Yeah, no, it's all right.
I
We
know.
gave you a little extra time.
No, I appreciate that very much.
and we appreciate
It's
your-
not only an argument that I'm making, I think it's an argument that's based on the evidence, and I think it's an argument that's correct.
Understand that. Yes,
Thank
sir.
you very much.
Yeah. Mr. Frame? Oh, you don't have any left. No, I'm not going to just give it to you. You didn't sign up for it. You used it. All right. I want to recognize you, Mr. Frame. You were court appointed? Yeah, well, I want to recognize your service. It's an important service, as I've observed earlier today, and thank you very much for your service to the court. Of course, always the public defender. And I might as well include you as U.S. Attorney. Thank you for your argument. We'll come down, we'll adjourn court for the day, sine die, and come down and recounsel.
This honorable court stands adjourned, sine die. God save the United States and this honorable court.